Hello, my name is Jacob Hugentobler, and I'm an attorney here at the Packard Law Firm. And today's video is going to be about avoiding the common pitfalls when you build your medical evidence for your disability case and you receive treatment from your providers. Now, I've represented about 500 cases about now, and I've won most of them, but I've also lost a lot of them too, and I've tried to learn lessons from the ones that don't work out. So, having read dozens of unfavorable decisions by certain judges, I want to bring to you the tips that I have about the evidence that often leads to an unfavorable decision, and hopefully you can avoid it when you get medical treatment. So our first problem that you want to avoid is non-compliance. Please take your medications as they are prescribed by your doctors. Go to your physical therapy, do your home exercise programs, so that your file does not say non-compliance anywhere in your medical records. Nothing frustrates judges and disability attorneys more than non-compliance with treatment. One judge even told me one time that having all the pain pills prescribed in the world doesn't actually prove the pain is real until he sees the drug test showing that the medications are actually being ingested. And speaking of pain, that brings us to our second pitfall, which is the 0 to 10 pain scale. When you are in the clinical setting and you are filling out the form, do not report your number on that pain scale if it's a good day, because the truth is you don't have very many good days. Otherwise you wouldn't be applying for disability benefits. The best response to that question is what your pain is like on an average day. And if you happen to be there on a bad day where your pain levels are really high, then report those and consider going to the emergency room. The third pitfall to avoid is a normal physical exam. So when you're in the clinical setting and you're receiving a physical exam from maybe a nurse practitioner or even the doctor, you need to remember to not hold anything back. So if raising your arm above a certain range hurts, you need to say that. If twisting a certain way hurts, you need to say that. If lifting your legs a certain height or against a certain amount of resistance hurts or it's hard to do, you need to tell your provider that. Otherwise, they're just going to write that every part of your physical exam was normal, and that's not consistent with somebody who's alleging tremendous difficulties in their everyday life with those specific parts of their body. The fourth is drugs and alcohol. Do not take illegal drugs because they interfere with the efficacy of your medications. Do not drink more than your doctor recommends. And if your disability is a respiratory illness, then please reduce the number of cigarettes that you are smoking as fast as you can so you can quit as fast as you can. Because judges will ask questions about all three of these in your disability hearing. Fifth is when your doctor greets you and they ask, "How are you doing today?" they're going to write down your answer. And your answer cannot be, "I'm doing fine, I'm okay, same as always," because that's what normal patients with no disabilities respond. You are disabled, and therefore none of those are true. The best response is to tell that provider exactly how your disability limits your everyday life in specific ways. So I recommend thinking about that and writing those answers down before you go into that clinical setting so that you're ready to answer that question. Plus, that information is probably going to be more helpful for your doctors anyway. As I've said at the beginning of this video, I have lost a lot of cases and I've learned a lot of lessons from doing that. Yes, if your judge wants to deny your case, then the judge will go looking for when you are reporting very limited amounts of pain. They will go looking for non-compliance with treatment. If your condition is made worse by drugs and alcohol and cigarettes, then they will go looking for active evidence that you are using those particular things. And if they don't believe you about the level of pain or the severity of your condition, they're going to look for the physical exam where everything appeared to be normal. They were looking for all of these unhelpful items of evidence to find inconsistencies in the record between what my clients were telling the judge there in the hearing and what they had told their doctors a year or two even before that. If your case has not been set for a hearing with an administrative law judge, then it's very hard to say whether these actually exist in your medical records right now. But when your disability attorney talks with you before the hearing, about a month before your hearing, then your disability attorney will be able to tell you if any of these unfavorable items of evidence exist in your file. So I hope this really helps you understand how to avoid the most negative evidence to be found in a disability case so that you can build the strongest case possible. If you have any questions about this, then please contact the Packard Law Firm at 210-340-8877. Thank you.